We are handing down our judgment in this matter in writing. Copies of the full written judgment will be available alongside a written press summary. I will now be giving an oral summary of our decision. As with the written press summary, what I say by way of oral summary does not form any part of the judgment itself. The judgment itself is contained exclusively in the written judgment, as I say, copies of which will be available at the end of my summary. Summary.
Buckle up, guys. Today we are going to witness a courtroom moment where the stakes are already set before the details even land. The judge opens with a firm reminder. This oral summary is not the judgment itself, but a guide to what has been formally decided. Written copies are coming, precision matters, and every word signals that a serious, carefully reasoned decision about life, death, and responsibility is about to unfold.
The applicant sought leave to appeal his conviction following a retrial before Mr. Justice Johnson and a jury at Canterbury Crown Court on the 19th of February 2024 of a single count of facilitating a breach of UK immigration law and 4 counts of gross negligence manslaughter. He also sought leave to appeal the sentence imposed on him by Mr. Justice Johnson of 9 years and 6 months detention, comprised of 4 concurrent sentences of 9 years and 6 months detention in respect of each gross negligence manslaughter count, and a concurrent sentence of 4 years detention for the immigration offence. The factual background is thus. The applicant, treated as being 20 years old at the time of conviction, had travelled from Senegal with the intention of claiming asylum in the UK. Whilst awaiting the opportunity to make the channel crossing in the area near Dunkirk known as the Jungle, the applicant was approached by a trafficker who offered him free passage to him and a friend if he agreed to steer the boat across the channel. The applicant agreed, not otherwise having the means to make the crossing. The crossing was to occur that evening. The traffickers provided the inflatable boat which was to be used and put the applicant under some verbal and physical pressure not to break the agreement. At about 30 minutes past midnight on 14th of December 2022, the boat set off with around 45 persons on board. 2 of the passengers were navigating, using their mobile phones and giving instructions to the applicant, who was steering the boat. After about an hour, water started to enter the boat. Panic set in.
The court then lays out the case history. A young asylum seeker, a desperate journey, and an offer from traffickers steer a boat across the channel in exchange for passage. Under pressure, he agrees. Dozens board an overcrowded inflatable at night. Water seeps in, panic spreads, the floor collapses, and people are trapped. 4 die before rescue arrives. The tragedy is framed not as chaos alone, but as a chain of choices leading to fatal consequences.
As a consequence of passengers standing up, the floor of the boat broke and the boat collapsed in on itself, trapping some of the passengers. At least 4 passengers died. The survivors were rescued by a nearby fishing boat, the Arcturus, towards which the applicant was able to steer. The application for leave to appeal against conviction. The applicant sought leave to appeal on 3 grounds. 1, that there was a jury irregularity that had prevented him from having a fair trial. 2, that the judge was wrong to reject the defence submission at the close of the prosecution case that the applicant had no case to answer in relation to the manslaughter counts, because the prosecution had failed to establish that the applicant's acts were a significant or more than minimal cause of each death. And thirdly, the judge erred by failing to direct the jury that the deceased's voluntary choice to risk death by joining the channel crossing was relevant to whether or not the applicant's acts were causative of each death. The court, we found that there was no merit in the jury irregularity ground. The alleged irregularity was raised only after the applicant's conviction. The Attorney General, following an investigation into the alleged irregularity, had decided to take no further action. There was no evidence that, beyond the alleged external misconduct, there was any irregularity in the jury's conduct at trial, such as to render the convictions unsafe. The second and third grounds were closely related. The primary question raised by each was whether the deceased's free, voluntary, and informed decisions to board the boat and embark on the crossing broke the chain of causation, meaning that the applicant was not legally responsible for the deaths. The key authorities relied upon by the applicant were Kennedy in 2007 and Rebello in 2019 and 2021. We concluded that it was not arguable that the judge was wrong to refuse the defence submission of no case to answer, or arguable that he had erred by failing to give the direction sought by the defence. The judge was entitled to find that both Kennedy and Rebello were very different cases. In those cases, the voluntary actions of the deceased were properly regarded as separate and distinct from the acts of the appellant. In this case, our case, there was no separate act by the deceased that broke the chain of causation. Further distinguishing the authorities from our case, in each of Rebello and Kennedy,
attention shifts to the appeal against conviction. The defense argues jury irregularity and claims the victim's own decisions to board the boat broke the legal chain of causation. The court disagrees. It finds no proof of jury misconduct and rules the key precedents don't apply. Here, everyone was acting together in one criminal episode. In such situations, one person's voluntary risk does not erase another's responsibility for the deadly outcome.
The appellant and the deceased were not acting together. In this case, whilst the applicant and the deceased were not joint offenders, they were undoubtedly acting in concert. In other words, they were acting together with the same aims in the same single criminal episode that ended in the deaths. It is a fundamental, uncontroversial principle that where both actors are acting in concert, the free, deliberate, and informed decision of one of them will not normally relieve the first of criminal responsibility. The application for leave to appeal against conviction was accordingly refused. The application for leave to appeal against sentence. The applicant sought leave to appeal against sentence on the basis that each sentence was manifestly excessive on the following grounds. In relation to the immigration offence, it was argued that the judge was wrong to assess harm as high, and he therefore adopted too high a starting point for the sentence, resulting in a final sentence that was too long. Secondly, it was argued that the sentences for the manslaughter offences were too long because the judge erred in assessing the applicant's culpability as high and therefore again adopted too high a starting point. It is said that the judge made too large an upward adjustment to reflect the fact that there were 4 deaths and that he failed to give adequate weight to the applicant's youth and his other mitigation. It is suggested that he failed to have adequate regard.
The focus turns to sentencing. The defense calls the terms excessive, arguing harm and culpability were rated too high, and that the judge gave insufficient weight to youth, mitigation, and overall fairness. The court rejects each point. It holds that steering an overcrowded boat in dangerous conditions showed clear disregard for life. Even if traffickers bore primary blame, persistence in the conduct justified the high assessment and the structure of the final term.
To the principle of totality, to ensure that the overall sentence was just and proportionate. The court, we, concluded that these grounds were also not arguable. The judge was entitled to conclude that the harm of the immigration offence was high for the reasons that he gave. The judge was also entitled to conclude that the applicant's culpability for manslaughter was high. Though primary responsibility for the overall offending lay with the traffickers, the applicant persisted in the conduct which arose in the context of other serious criminality and demonstrated a clear disregard for the high risk of death. Further, the overall reduction made by the judge, incorporating an adjustment for the applicant's youth, reflected adequately the relevant mitigation. The judge also had proper regard to the principle of totality, and there is no basis for interference with his assessment that the final sentence was proportionate to the overall offending. For these reasons, the application for leave to appeal against sentence was also refused. Now, if we can hand out the written judgment, please, and the written press summary for those in court. In the normal way, the judgment we put up on the National Archives with the case reference 2024 EWCA CRIM 1499. Thank you all very much.
The court's conclusion is direct and final. There is no arguable error in conviction or sentence. Both applications for leave to appeal are refused. The judge confirms the written judgment will be published and formally distributed, closing the matter with procedural clarity. What began as a desperate crossing ends as a firm statement of legal accountability at the highest level of review. Like the video, subscribe to the channel, and we'll see you in the next video.